as we know, the H-1B registration is done, and there won't be any more H-1s until next year. So in the interim period, we're always thinking as attorneys about how to bring, fulfill our clients' needs. If they need to come during the time, if they need to work during the time that H-1s are not available, especially if they're subject to the cap. So, and we often disregard or don't pay attention to some other work visas that are available. I do understand the reason why these work visas are in the fringe is because they're rather difficult to obtain, but you never know until you have at least some basic idea as to what, how to get it, or you never know whether you qualify or not. So it's important to have some information about these alternative work visas to a H-1 and see if you qualify. If you are the beneficiary or if you are the employer, maybe you qualify and you don't know. Recent policy guideline, recent meeting in January of this year, where they clarified how USCIS evaluates the evidence to determine the eligibility for H-1B based on STEM, specifically on STEM, because some of their forms of evidence so the O1, just to backtrack, O1 is not just for people from STEM, it's also for people in the arts, it's for people in the sciences, it's for business, it's for athletics. The general standards for classification of an O1 is extraordinary ability in that particular field. So in the field of science, education, business or athletics, a level of expertise indicating that the person is one of a small percentage who have risen to the very top of their field of endeavor. So O1 is obviously not for everyone. It's for a person who has excelled and come to the top of their particular field. So we just have to remember that general standard of classification for an O1 when we talk about O1s in general, whether it be STEM O1s or otherwise. The eligibility criteria is basically extraordinary ability in the sciences, education, business or athletics. The achievement would have to have been recognized in the field through extensive documentation. So we have to show that he or she is recognized in their field and be able to provide extensive documentation. And that person should have demonstrated sustained national or international acclaim. Number 2. Number 3 is the person is coming to the US to work in that particular field. That's number 3. The supporting documents has to show evidence that the beneficiary has received major international, either major international recognition award. If you have that one thing, then you don't need anything else. But how many of us are Nobel Prize winners, right? So if you have a Nobel Prize, you don't really need anything else, or something that is similar or of the same, criteria. But if you don't, like most of us, then they document 9 points. Out of that, you have to at least meet 3. One of the criteria for the O1 for arts or STEM or movies or whatever the area might be in is that they should be coming to the US, or if they're already in the US, they should continue to work in their area of extraordinary ability. So that's one of the criteria. But again, there is some leeway here. There is some way for us to, even if they're not working in that exact field, in that exact area, USCIS is still willing to look at those applications and make a determination as long as certain standards are met, right? So when you're considering a petition for a beneficiary who is transitioning, say, to a new occupation, for example, you might be a professor or an academic researcher, and you've received all your acclaim based on that. So you're working in the field of robotics as a professor, and you've researched, some new element of robotics, and you've written papers on it, etc., etc. It's not necessary that you should be coming to the US to work as a professor. It could be that you have been hired by a private company, a robotics company, so that you can use your expertise then in industry. So is that will be considered to be continuing in your area of expertise. So there's no statutory or regulatory definition to define the field or area of expertise or area of extraordinary ability. So again, they look at the totality of the circumstances. So you see a lot of this is subjective, because the officer does have a lot of say in ability to make decisions based on the totality of circumstances.
Right.
Everything is not written down, and they don't have to follow the exact criteria that's written down.
Right.
There's a lot of areas for them to make their own determination.